Welcome in, everyone. Back after about a 6-week hiatus. I am Mark Reel Jr., and this is State of the Family Courts. It is Thursday, May 12th, 2022, and joining us tonight is Texas attorney Ben Beveridge. Welcome, Ben. Thank you for joining us tonight.
Thank you. Thanks for having me. Looking forward to it.
Yeah, so I'm really excited to have Ben on. Many of you in the equal and shared parenting community are probably familiar with his work, have heard his name, have seen him in various areas, especially in the state of Texas, where they've really pushed the envelope and they've passed some more positive legislation, and we'll talk about it here in a second. Got hopefully more on the docket in 2023. So we'll kind of hop right in here, Ben, and I'll let you introduce yourself. And I think obviously you have a really cool, unique story on how you ended up where you're at today, and then what you do in terms of your really area of practice within family law.
Okay. Yeah, you bet. So, I started off as a non-custodial parent, about 15 years ago now. And, I never got denied access to my kids by their mother, but just what they call in Texas a standard possession order. I couldn't stomach it. I never got used to it. I just always wanted more time with my kids. And about 8 years ago, I got started with the father's rights movement in Texas, and I kind of got involved in some legislative stuff, and I kind of found out about equal parenting and this concept of equal parenting. I found out it's widely accepted among researchers all over the world. Past 2 decades, it's like that's the golden standard. They all know children need equal access to their parents. And I've decided that I was going to get equal access to my kids, and I would litigate until they turned 18, if that's what it took. And I know plenty of people that spent over $100,000 trying to get equal access to their kids, and didn't get it. And so I figured, I'm just going to go to law school and I'll litigate myself, and if I'm going to be spending all that money. And I went to law school. My last semester of law school, I filed the modification in my case to try to get equal access to my kids. And about 2 months after I passed the bar and started practicing, I signed a mediated settlement agreement. They gave me equal access to my kids. And actually, I did that mediation at a firm called Goldsberry and Associates. Miss Goldsberry mediated my case. And it was a room called the Lincoln Room. They have pictures of Abraham Lincoln. After I started practicing law for about a year, I actually went back to work. I went to work for Miss Goldsberry. And, now I sit in the Lincoln Room with non-custodial parents, and I mediate their, cases with them and help them try to get equal access to their kids. So it's kind of a full circle type thing,
That's awesome. That's awesome. So the other thing that's unique about what you do in your current role is who you represent. And so I'll start out with, for our viewers, in case they don't know, I know we talk about a lot of this stuff like it's the back of our hand, but the Texas Standard Possession Order, or I guess is it the expanded or extended? What is the term?
Well, there's kind of 2 of them. One's the Standard Possession Order. That's the one that had been in place for, decades. And there was also always what's called the Expanded Standard Possession Order. And used to, the Standard Possession Order was the presumption. And what that is non-custodial parents get their kids first, third, and fifth weekends from Friday at 6 to Sunday at 6, 2 hours on Thursdays, and then, holidays and summer and holidays. And what the Expanded Standard Possession Order is your Friday actually starts when the kids get out of school on Friday, and then you keep them until the kids return to school on Monday, and your Thursday is an overnight. So when you have them just on Thursdays, you get them for the overnight, but it's when it's your weekend, you get them from Thursday when they get out of school until Monday when they go back. But now that expanded Standard Possession Order, as of the last legislative session, is now the standard. Essentially, it's the presumption. So it's not quite equal possession, but it's a huge improvement over what we've had.
Yeah, and so you had I know a lot of people in the state of Texas were disappointed in 2021 when the legislative session ended, but that expanded order was really from an attorney's perspective is a huge win. That starting point is so much further along. And prior to going on, you said if you take the school time out for kids, it's like a 53-47 split in terms of actual time with the kids, which is a big deal. Where so what's and I know we can't share all the details, and I know you're intimately involved in a lot of what's going on in Texas, but what are kind of some of the broad brush? It's an every other year state, so you made the run in 2021, and some legislators kind of got in the way despite you guys having the votes. So what's in the plans for 2023 in the state of Texas?
Well, first, I don't want to take too much credit as far as legislative session goes. I used to be heavily involved. I wrote some of the legislation before. I would line up the reps. But since I started practicing, I haven't been as involved as I'd like to be. But I'm coordinating with the people at the National Parenting Organization. They're doing a huge push in Texas, and a few other people. So, yeah, as far as possession schedules go, that expanded standard possession order, if you just add one extra Wednesday overnight a week, that turns it into a 2-2-3, 50-50 possession schedule. And it's nice because when you go into mediation or something, you say, look, all we want is one extra Wednesday a week. Tell her that, and it's not such a big deal. And the kids are in school on Wednesdays, so it's really additional 4 hours of possession time a week. That's what we're talking about here. We can settle or go to court over that. And so one of the kind of common sense legislation bills is making it to where you can elect to have that extra Wednesday a week. You had the presumption for standard possession order, and you could elect the expanded standard, but now we'd like to do something where you get the expanded standard and you can elect to have your extra Wednesdays. And so it's essentially electing 50-50 order possession schedule. It's not as good as just having it presumed you're going to get it, but it's a baby step. And what we've learned in Texas is it's better to get a baby step than nothing.
Yeah, I think we've seen that. I mean, realistically, outside of Arkansas, every state has been each year, each session you take a baby step. West Virginia in their first real push didn't get anything. Their second year they get a 30. If one parent doesn't get at least 35%, there's facts, findings, and conclusions of law. And then in year 3, they broke through and got the presumption. I like that angle, though, around instead of just saying we want a presumption of 50-50 custody, you essentially have the opportunity, or there's legislation that's going to go in front of your legislative body to essentially make the 2-2-3 the standard possession. Rather than saying we want 50-50, you guys have make those baby steps, and now it's not talking about 50-50. Now it's like, hey, we just want those extra 4 hours after school on Wednesday, and you have it. Because I think a lot of the groups that oppose this legislation, they attack the broad brush presumption that it should be equal, and it's very vague. So what's been in terms of talking with legislators, or just in your opinion, do you think that's going to be impactful for you guys in Texas?
Yes, yeah. I mean, it's kind of hard to talk about what's going to be impactful because honestly, we've had the votes for years, 8 years, and so it's almost really not a question of what's going to work or what bills they are or not going to like. It all comes down to just the procedural mechanisms of the legislature, just getting past those gatekeepers, just getting it to the committee. And, if we ever, if we ever do that with any equal parenting bill, we're confident it'll pass. But yeah, to answer your question, I think it does. I think it helps us to pass something because one, it's not, they can't argue against it and say, hey, we don't want to make this huge change and make a presumption for equal possession. It's like all we're asking for is an extra Wednesday night a week. And so it's kind of, kind of try to sneak it in there as under the radar type thing, it's kind of hard to argue against. I don't know if it'll pass or not. It's so hard to say. The opposition in Texas are so influential. Just incredible. I mean, we've had legislature, senators and reps. I mean, I specifically remember one senator told us, look, whatever the Texas Family Law Foundation tells us to do in family law, we're going to do it. And so that's what we're up against in Texas. But yeah, I hope a bill like this that makes it seem like a nonchalant little change will kind of help slide it in.
Because I correct me if I'm wrong, if you know better, but I don't think a bill that's ever made it to a general vote in terms of equal and shared parenting has ever failed. They die in committee. I mean, I know there are some states that it's literally one state senator that is presenting, Minnesota, Alabama, some of these other states where it's just one or two people holding up equal and shared parenting. So I think that says a lot that anything that gets to a general vote, it has passed. Because I know
definitely. Yeah, once they get to the floor, I mean, it's a pass. And I mean, so the state reps and senators are in favor of it, but I mean, the population's in favor of it because every single, not study, but poll that I've seen where they poll the population's overwhelmingly in favor of it,
Go to sharedparenting.org, NPO's website. Every single state they've polled has at least 80% of the population in favor of equal and shared parenting.
Yeah, I mean, it's literally just the special interest going against democracy, basically, and pulling their strings. And that's the only thing that's holding it up is special interest,
I've told people, and I guess I've been saying it for over a year now, so I need to adjust my years. But I've always said in the next 2 to 5 years, this is going to become one of the hot button social justice issues. This impacts more of the population than any other movement in human history outside of suffrage in the 1920s. There's more people that are impacted by this because it's both men and women. It's men and women. It's grandparents, parents, kids. There's so many different demographics that are impacted by it. But it's just at some point in time, there's going to be a snowball. Is that, we got Arkansas, then we got West Virginia. There's I guess there's still a few states that are on the table potentially this year. But 2023, 2024, I just anticipate there's going to be a snowball of states that just fall.
Yeah, I think so. I mean, obviously the first one is the toughest to get, because the opposition is like, we're going to put something in place that no one else is doing, it doesn't. But yeah, once you get a few of them start going, it makes it easier to sell to the legislature, and the legislatures kind of start to they know which way it's going, so you might as well get on top of it, and own it. But yeah, no, I don't know. I don't know when that's going to happen. It seems like, it's moving so slow, but I don't know. Maybe it's moving kind of quick compared to how legislation, it's a slow process.
Yeah, that's the thing. You talk to people who have been at this for a decade or more. I mean, really nothing happened. I mean, 2017 in Kentucky. And I think it was in Texas. I think it was one of your senators that we're starting to get data and information out of Kentucky on what these laws do. And one of your senators was like, but we're talking about Kentucky. But now we're going to have Kentucky. We have Arkansas. We have West Virginia. And the list is only going to grow, and it's going to be harder to refute by saying, oh, that's just little old Kentucky.
Yeah, it's just ridiculous that, all these states have always had this presumption that children should be essentially sentenced to single parent households and subject to single parent statistics. I mean, it drives me crazy that you look at all these statistics regarding single, children in single parent households, higher incarceration rates, drug use, teen pregnancy. I mean, just about every ill you can think of concerning a children.
Yeah.
And it's like, yeah, our courts are ordering children's into those statistics, and people don't like to hear that, but most single parent households are court ordered to be that way.
Well, I think it was the state of Texas considers an at-risk child someone who spends was like less than 30% of their time with one of their parents, and it was the standard possession order actually ordered these kids to be at-risk children. It made zero sense.
Yeah. I know, Dr. Linda Nielsen and the studies she's done. I mean, she defines a single parent family, or when a child has less than 35% access to one of their parents, actually. And yeah, the Texas standard possession order was around 23 to 24%. And that's only because in the summer, the child spends a whole month with their non-custodial parent. But if you factor out that summer and look at the other 11 months, it drops down to like 18 or 17% for 11 months of the year, and that's why you have so much litigation, right? No one wants to be that single 18% parent.
Here's a good question on our topic we're on now. So we mentioned special interests. So in the state of Texas, who are the special interests that you guys have had your battles with?
Well, you got the family law section of the state bar, who doesn't really get involved because they're not allowed to. It's illegal, and so there's a organization called the Texas Family Law Foundation, which is a C6 nonprofit, and a C6 nonprofit is a group that's formed to represent the interest of a given industry, like the NFL is a C6. It represents the football industry. Well, here you have family law attorneys. This group is literally formed to represent the interest of family law attorneys in Texas. And I think maybe 1 in 6 members of the family law attorneys in Texas are a member of that group. I don't know, but it's thousands of people. And, that's one of the problems in Texas. Since they have this massive group of dues paying members, they have a lot of money to pay their lobbyists. And our legislative session only happens once every 2 years. So, they pay Steve and Amy Bresnans, the lobbyists for them. And, these are lobbyists that represent AT&T and, a lot of other interests. But yeah, they have a tremendously good relationship with the gatekeepers, the chair people of the committees, and for the longest time, the chairperson of the committee he wouldn't give our bill a vote until like a month before the session ends or weeks before the session ends, and then he would vote on it, and other people would vote on it too, but it's too late to pass. But yeah, it's the Texas Family Law Foundation, and every year, when these bills when everyone shows up to testify on the bills, I mean, you have a handful of family law attorneys, and like last session, it was like 180, parents and everyone testifying in favor of the bills. It was, it's like a joke. And then they vote against the bills or vote for them, and it dies. But it's family law attorneys and the people who they pay to kill the bills.
Yeah, in general, I mean, I think every state has one well-funded foe. In West Virginia, National Organization of Women was one that really came after their bills. But I mean, in general, in terms of groups, yeah, family law attorneys, judges don't like losing their discretion. and then women's groups and domestic violence groups. Like usually the opposition falls into one of those four categories. Varies depending on state. Obviously, like Ben said, Texas has a very powerful organization, very well-funded organization in terms of family law attorneys. But then, like I said, West Virginia, their struggle was the local chapter of National Organization of Women was obviously very well funded compared to the grassroots efforts of what amounts to essentially building steam up in Facebook groups and rallying as many parents as possible. Because you guys in Texas, it wasn't always 180 parents showing up. That's something that's a decade long in the making.
Yeah, definitely. And as far as those other groups, we don't have like any domestic violence groups or any like women's organization groups. It's just the family law attorneys, But yeah, it's been a while as far as, in Texas. And of course, Facebook and social media helped out in every state, tremendously. It gave these non-custodial parents a place to come together, and it gave everybody a voice. And when I got involved, there had been groups before me, but really since I've got involved, it's grown almost exponentially. Getting 180 people out there to testify. That's kind of part of the exponential growth. But there's people who've been at it for a long time and who are still just as gung ho about it. You have Rustin Wright, and he was at it before I came along, and he's still he's one of the most involved persons I know. But yeah, it's been coming for a while.
Yeah, because that's honestly is one of the biggest struggles with really the movement is that, if a parent stops fighting, a parent gives up, a parent gets what they want, a lot of times those people fall off. And when the groups are not well funded, you need all that grassroots effort. Every single state that's passed one has had, outside of Arkansas, I will say Arkansas was extremely tactical in how they did it. But all the other states that have made progress, it's been a lot of times by brute force and just building an army of people. So
yeah, we've actually, the brute force approach has gotten us in trouble, and sometimes because you get some of those outliers who say one thing crazy, and that our opposition have done a really, really good job as painting all proponents for equal parenting as dads who are trying to get out of child support, angry dads. That's pretty much it. They've done a good job of painting us into that corner, and it's because they'll find someone who's made some offhand comment on a Facebook group, and it's like, look, this is what the members of the fathers' rights movement, this is how they behave. This is how they really feel, and it's really gotten us in trouble. I don't think Texas even has a Facebook page anymore for the fathers' rights movement. We've really had to kind of try to control our message.
Yeah, that's one of the things we're fighting in legislation is they're going to characterize it as that. And that's why I mentioned Arkansas was extremely tactical. They were almost covert in the way they went about it. Like it was a need to know basis. It was an extremely tight group of dedicated people. And it was too late before anyone really knew what they were doing and what they had gotten done. Because they did it in 2 legislative sessions. I think they're on an every other year basis as well too. They tried, learned from their mistakes, came back a second time, and now have what is the best law in the country in regards to that. So, but I agree with you 100%. I always tell people the biggest growth in this movement is with the invention of Facebook groups. That's been the single most powerful thing because, especially as men, are we going to go and talk about our struggles we're having in family court? No, but for some reason, we find a group with the right title name, and we tell our story to a bunch of strangers, and all of a sudden, we have hundreds of men saying the same thing happened to me. And so that's extremely powerful.
Yeah, it was almost, and it kind of still is, kind of faux pas to talk about the struggle of the non-custodial parent. you know, it's like who wants to hear that? And I mean, the almost knee-jerk reaction was, oh, you just don't want to pay child support.
Yeah.
And I still get that sometimes. I remember it wasn't too long ago. I was talking to my good friend, man, and we were talking about equal parenting, and he's not really that into it. And we were talking about a radio show host. I go, I wonder what that radio show host, what he would think about equal parenting. He goes, well, he would probably just think that men need to take care of their responsibilities. So in his mind, he was thinking I was talking about not paying child support. But yeah, you get these Facebook groups together and everyone starts to realize it's okay to say this, there's something really wrong going on here. And, everyone starts to realize that this is almost like an identity, the screwed over non-custodial parent. And it's okay to be pissed off like that because it's affecting your children, and that everyone's on your side as far as social scientists, and all the common sense arguments. They're all on your side that we should be having equal access to our kids. And yeah, social media has, without that, we wouldn't. I bet not one state would have equal possession laws.
Yeah, I agree. I mean, it brings together people who would never speak, even neighbors that would never speak about their situation. Social media has brought them together. I mean, I just think about over the last 4 or 5 years for me, the number of people who live down the street, who live in my communities that I now get to serve that I would have never met if it wasn't for us sharing our stories in these social media groups. All right, so we'll go ahead. We talked a lot about legislation, a lot about where things are going. We'll twist to kind of the here and now. So the way I usually start off with our guests is, so Dad walks into your office and says, "What's going to happen to me?" What's the process look like? What do you tell that dad in that first meeting?
It depends. I serve kind of 3 counties where I am. And so, part of it depends on what county we're in. For instance, if you're in Galveston County, I'm going to tell you, look, we file this petition. We'll ask for equal possession time, or in the alternative, the standard possession order. And we go in there on temporary orders is the first thing that happens. And I tell them, look, there's, in Galveston County, there's 3 courts that handle family law issues, and they all share one associate judge. And you got to go through the associate judge before you get to the presiding judge. And I tell them, look, when we go to that associate judge, no matter what we say or what evidence we put on, he's going to order you to pay child support. He's going to give you the minimum amount of possession time the law can allow. He's going to give mom the exclusive right to make educational decisions, and then from there we can appeal that basically to the district court. But I tell you, right off the bat, you're going to lose with this judge, and it depends on what county you're in, but generally it's we'll serve your ex, and then we'll either do mediation or temporary orders. And then after that, if we don't come to terms, we'll do discovery for a few months, and we'll do mediation again, go in there for a final trial. Texas is unique because you can actually have jury trials in family law issues. So, I tell the clients, look, if we go in front of the judge on temporary orders and you lose, I mean, after that, if you don't find out anything tremendous in discovery, you probably either want to settle because you don't want to have this judge hear your case again. You already know what they think about it. Yeah. Or you ask for a jury trial, which, obviously is going to be a lot more expensive. But, that's kind of your options. And in Texas, I don't think it's too different from many other states. You hope they agree along the way, and if they don't, your chances aren't too good in front of the judge.
Yeah, see, this is what's scary. So California is, we talked a little bit before, it can be a crapshoot because mediation is mandatory. And in some counties, those mediators make recommendations. So you end up with a young social worker making a recommendation on custody and visitation. And we don't do necessarily temporary orders. Like, you're going to file, you're going to go to mediation, and 2 or 3 months down the road, you're going to be in front of the judge. And the mediators are wildly inconsistent. The judges have broad discretion. Some judges rubber stamp the mediation reports, even though there's really nothing behind them other than just an uneducated opinion. And other judges are just absolute wild cards. I will say, I've been practicing for almost an entire year now. I've seen a dramatic shift in judges being willing. We get the mediation report back and it's close to 50-50, or it's a 40-60 split of leaning towards the side of we need to maximize the time with each parent. That's one thing I'm hopeful about. I had a judge the other day who looked at mom and said, I'm in the business of making sure kids spend as much time as possible with both parents. So we're moving in the right direction, but I'd be curious to have your opinion on this. So California, it's kind of the Wild West. The judge can really do whatever they want. Where Texas, you have the standard possession order. In your opinion, is limiting the judicial discretion, because this is a topic that comes up, is that a positive or is that a negative for non-custodial parents?
I mean, it depends on, I think it's a positive to limit the discretion, as long as, the presumption is for equal possession, right? And then limit their discretion. I mean, it goes back to, right now the starting point is the standard, or, the expanded standard possession order, and then a judge can make adjustments as necessary. Well, we want to start off at 50-50, and then the judge can deviate from there as necessary, So, I mean, that's one of the things our opponents harp on is, our, 50-50 schedules are going to tie the judge's hands and it's going to limit the discretion. And I mean, right now, everybody knows there's a rebuttable presumption for the standard possession order. So, I mean, I didn't know California was like that. And, but for me, at least in Texas, it's like the judge's hands are always going to be tied because you're always going to give the judge some direction. We don't want the Wild West. You got to have some predictability.
Guidelines.
Yeah, guidelines.
Guidelines in Texas. That's the thing. I think there's zero consistency. And at least if you have those guardrails, you have some level of consistency and you can adapt and adjust to that. California, you have no idea.
The Texas, one thing is this Texas standard possession order, the family law attorneys and the legislature, they're very proud of that order because it is extremely detailed. I mean, you can say, all right, we're going to put in the standard possession order. And you know what? I mean, your whole possession order down to the hour, just from the standard possession order. And so, yeah, it's good to have guidelines, but I mean, all over Texas, you mentioned the judge rubber stamping the mediation reports. And the most common thing in Texas is judges rubber stamping that standard possession order. Everyone gets a standard possession order. They'll deviate and give the non-custodial parent less time if there's, abuse or neglect or something like that. But they rarely deviate the other way and give the non-custodial parent more time, So it sounds like California and Texas are maybe at two opposite ends of the extreme,
Yeah, definitely. So the next piece is something that's unique to Texas. And I guess I'll start. I kind of know the answer to this question, but the jury trial thing. I know both of us, we could say we kind of got our starts in the Facebook groups and social media and everything. And that's always a lot. There's always a lot of chatter in Texas around that. Oh, file for a jury trial. Do those happen very often? I mean, they're very impractical. And do you think that's a good or a bad thing?
They don't happen very often. And that's because most family law attorneys, they don't want to do them. It's a lot more work. And I think a lot of them don't know how to do them. I mean, there are very, very few jury trials in family law in Texas. I've done one. I've only done one, but I definitely, I want to do more. But in Texas, the jury trial, only thing they can decide are what's called conservatorship, and that goes to like the legal rights of the parents. Are you joint managing conservators? Are you sole managing conservators? And they can assign a geographical restriction, but they can't decide possession, which is visitation. They can't decide child support. Those are the two main things. So I mean, I like having it on the table because, again, if the judge rules against your temporary orders and nothing has changed too much, you have that jury trial option. But you had judges, again, you could win the jury trial, and the jury will say, okay, your guy is number one. He has the right to designate the primary residence. He has all these rights and duties. And then the judge will say, okay, yeah, that's nice. I'm going to let mom have the majority of the time and make dad pay child support. So that doesn't happen too often, but you could win the jury trial, and then the judge still has discretion on visitation and child support. If the judge doesn't like you, you can't get away from them. They're gonna put in something bad. But I definitely love having the option of a jury trial. One thing, a jury trial is, most people in society, they think mom's the primary parent, and so just because you have the option of a jury trial, you think, oh, I'm going to tell them all these arguments about how moms and versus dads and all this stuff. But I mean, you still have, you got a bias with the judge. You have a bias with the general population as well. So it's not like, you're starting with 12 people who are going to see things your way. It's still a challenge.
Definitely. So next topic, something again we chatted a little bit beforehand, is that with the onset of COVID, we saw remote proceedings, and I believe in Texas you guys use YouTube, correct?
Zoom.
Zoom. Okay, you guys use Zoom. We use Zoom, WebEx, a little bit of everything. And it seems like one of the cool things that it seems it to do is to get all your friends and rile up Facebook groups to show up at your hearing to be court watchers, and really just to piss the judge off. What's your opinion on that, and what advice would you give to dads kind of around that topic?
Yeah, I like Zoom hearings, and we do use YouTube for viewers to watch the hearing. If you participate, you use Zoom, but you can watch on YouTube. Uh, I think it's a fine idea, and there's nothing wrong with it. If you want to get some court watchers to watch you and just look out for any wrongdoings or just anything they can report, which even if they see something that's crazy and biased, I mean, what are you going to do with that information? But you don't, I think you never want to do anything that pisses off the judge. The judge is the decision maker in your case, and you never ever want to piss off the judge for any reason, unless if sometimes if you're going to appeal them, that might piss them off. But if you got a legitimate, gripe, but I'm against having court watchers show up or watch your deal if they're going to cause any trouble at all. If they're going to be making offhand comments that the judge can see, if they're, if they're in court and I don't know, they're making faces or something like that. You don't want to do anything to piss the judge off, because judges are people too, and they, if they get pissed off at you, just like anyone else, they're less likely to give you what you want. And a lot of times the court watchers, a lot of times it gets people in trouble, and I'm against it unless the people are literally just going to sit there and watch and not say anything.
Yeah, I would say the same thing. At the end of the day, I mean, you no matter the struggle that it's been, you can't piss off the person that has the ultimate decision. So I mean, there is some accountability, and there are holding people account, but there's a very, I'll say, very thin line between accountability and then just pissing someone off that ultimately is going to hold some of the most important decisions in your entire life in their hands.
Yeah, if you're going to shoot at the king, don't miss, right?
Yeah.
So if you're going to, if you have a course of action you can take against the judge and you're likely to succeed, yeah, okay. But if if you're just going to, cause a judge issues, have people email the court and, post stuff on Facebook and rail against the court, that's not going to do you any good.
Yeah. Completely agree. So I'll post a couple questions here because I think there's some good ones, and we'll answer it Texas specific, and then I'll comment on it on kind of California, and we can talk in general. So this one's going to start out very Texas specific. So this is from when we were talking about the standard possession order, or the expanded standard possession order that now is presumed. So if you go in and the judge has the ability to give you less than that standard possession order, what do you do in cases where you want that and then the judge orders something less?
Where you say when you want it, you mean like where if you want the other parent to have less
Well, you're the
time?
non-custodial. So you're the non-custodial parent, and you go in and the judge orders you less time than even the standard possession order. What are your courses of action, or what are your next steps to kind of help protect your rights and increase the amount of time you have with your children?
Man, it's tough. You don't have a lot of next steps. I mean, if it's an associate judge, you can do what they call in Texas a de novo appeal and have the presiding judge hear it. But presiding judges don't want to go against their associate judges too often, so that's you have some success there. But in Texas, anything dealing with child support or possession or conservatorship, just about anything to do with the kid, it's revealed on an abusive discretion standard. And decisions regarding possession, child support, and conservatorship are rarely overturned. I mean, it's very, very rare. In fact, in Texas, the only time there's a heightened standard is if a judge says that you can have zero access to your kids. Well, the appellate court says, well, you can only do that if there's extreme circumstances, things like murder, hostage taken, and sexual exhibitionism. But short of that, a judge can do just about anything they want. So that just goes back to not pissing the judge off, and I don't know. I guess to be specific, if I was representing a client and the judge gave them less than the standard possession order, I would, listen very carefully if the judge gave a reason, and I would look at the facts in the case to see if there's something we can correct,
Mm-hmm.
But short of that, not much you can do, man.
Yeah. So, I mean, in a state like, it's different from state to state. So you get your initial orders here in California, and I would tell dads, keep coming back, keep showing up, keep filing requests for modification, because a lot of times in California, when a dad is persistent and a dad keeps coming back and a dad keeps showing up and keeps asking for more and is there for the right reasons, usually the judge is going to be inclined to continue to give you more to a certain point. But there are other states. I know Oklahoma, your neighbor to the north, is one of them. You have one shot at temporary orders. They're going to set temporary orders, and the only other way really to get it changed is to go to trial. So for our viewers in different states, it's different depending on the state. Some states are going to be if you continue to show up, you're going to get more. Others, it's like, okay, well, we have to go to trial if we want to modify this temporary order, which California is on one extreme. A state like Oklahoma is on the other, where temporary orders are what they are.
Yeah, no, you can get in there and try to modify temporary orders, but the judges want to see a change, something that's changed. And so you always have that burden of a material and substantial change. So like within a suit, if you're in a divorce or suit affecting parent-child relationship, and right off the bat you get less than the standard possession order. Yeah, I mean, within that same suit, I would definitely, if you know kind of why the judge did that, go back to file to modify the temporary orders, and then at final trial too, I think that would be a case where maybe you do take it to a final trial, because generally you get at least the standard possession order. But like if you get less than the standard possession order, um, and then you have a final trial, yeah, you can file a modification and go back. But I'm sure, like in California, it's a whole new suit. It's a ton of money, and it's a lot of uh, effort. I guess it just depends on the reasons. If you can figure out why you got less than the standard possession order.
Yeah, definitely. So here's a good question from Ron. More, I guess, philosophical than hard legal. So I'll let you take this one first. So I know a lot of dads really struggle going through this process mentally and emotionally, especially when you maybe have a co-parent who's difficult to deal with. What advice would you have for a dad who is struggling with those issues, even though maybe they have a pretty favorable custody arrangement or they have that 50-50 arrangement?
So is the question like if you're having trouble like with your ex?
Yeah,
Like,
so if you're having trouble with your ex, it doesn't feel like maybe you have that 50-50 order, but it doesn't feel that way because maybe he or she, whoever is grasping at that power, what advice would you have for a client who's going through that?
um, limit your communications with the other party. I mean, that's always, step one. I have a good book here. It's called BIFF, and it's a method for texting. It's specifically written for how to communicate with your ex in high conflict cases. And BIFF stands for brief, informative, friendly, and firm. And so there's and I have a good friend who's a psychiatrist, and kind of he's going through his own case, and we used to talk about this all the time about how to text, and how to respond to text messages. And I mean, a lot of it is, as hard as it is sometimes, not feeding in or taking the bait, and if your ex texts you and, accuses you of something or something like that, you just want to deny it and walk away, and just don't engage. And, a lot of times, when you don't give them the attention they're asking, those texts kind of dry off. If you're in the middle of a suit, you can actually reach out to the opposing attorney, and ask them to take care of that situation. And here in Texas, I mean, attorneys will actually do that. If I reach out to opposing counsel and, man, your client is saying this, and this to my client, I mean, they'll actually go and in certain cases and talk to them. But a lot of it, I think, is just acceptance. That God give me the grant, give me the, help me change the things I can, but grant me the serenity to accept the things I can't. I think that goes back to people that I can tell. I can't tell, but generally speaking, when I have a consult with a new client, the number one indicator of how they're going to do in court is like if I can get a read on how important their ego is to them, someone that just can't let stuff go, and someone who's going to, uh, uh, it sounds bad, but just assert their rights to everybody who, mildly, disagrees with them. I mean, it's just about, I think, letting go and controlling your ego. And I mean, I think that goes for dealing with your situation and for prevailing in court.
I'll say this: you just brought up a huge, I'll say, red flag in trying to get a non-custodial parent where they want to go are the individuals that have egos so large that they can't accept even the smallest concession, even if it's going to move them 10 steps forward. It's that makes it extremely hard when you're not flexible. I always tell people my communication tips. I tell every single client, any consultations, you're going to be brief, you're going to be peaceful, and you're going to talk directly about the child or children. That's it. If they want to go off topic, if they want to demand you take an answer like, okay, I don't agree right now, but I'll think about it, or you just let it go. So brief, peaceful, and directly about the child. But the ego piece, like, yeah, if you're put in a bad situation by the family courts, you cannot have an ego. If you want to get where you want to get, you're probably going to have to make some concessions on things that really don't matter to you. I tell all of our clients, I want you to list 1, 2, 3. What are the 3 non-negotiables you're going to have in this? If it's anything outside of those 3 non-negotiables, we need to be able to have a serious conversation about just letting it go, because you aren't going to get everything you want. You're not together with your co-parent for a reason. Things have transpired. So to be able to just swallow your pride and say that really doesn't matter can really, really help non-custodial parents move things forward, especially if your co-parent has an ego and loves to see you concede.
Yeah, no, I mean, I really think that's just the number one thing of, predicting someone's outcome in family court, because, I mean, the judges, they see this stuff all the time and they can pick up on it instantly through the tones and text messages and through, body language, the tone of your voice when you're testifying. I mean, they can tell if, someone is not being cooperative just because of ego, or because they don't want to concede. And, I tell people, when I was litigating my own case, when I communicated with opposing counsel, I started each email with good morning, good afternoon, good evening. If it was the weekend, I would end it with have a nice weekend. If we were walking into court at the same time, I would open the door for them and my ex. And, I mean, that's kind of going down a different road, but opposing counsel, yeah, they're going to litigate against you because they're paid to do it. It's their job. But you don't want them litigating against you because they're emotionally invested. They're emotionally charged and they don't like you. Because, I mean, a lawyer, especially a pro se litigant, if a lawyer doesn't like you, a lawyer can do bad things to you, and
yeah. I mean, a lot of times, like pro se litigants, they don't realize it, but I mean, it gets to a point where they're so difficult where it's like, okay, whatever, I'm not wasting my client's money having these conversations with you. I am in front of this judge on a weekly basis. I kind of know what they're going to decide. I'm going to say, do you want to accept this? If not, like, I don't need to have discussions with you. That's one of the things that I also find interesting in the group, on Facebook in general, in these groups. One of the most common questions is, well, does opposing counsel have to respond to my email? No, they don't. There's very few circumstances where they're compelled to respond to your email. And and the bar for them corresponding with you in those situations is extremely low. I will say I've had opposing parties who have been extremely difficult that our meet and confers have been me saying no. 1 word, 2 letters, and that met the burden. Like, no.
Yeah.
So, I mean, even attorney to attorney, and I as on kind of the other side of the bar, I mean, when I see an opposing counsel that I have a good relationship with, like, they'll informally give me a call and say, what's it going to take? And okay, that's reasonable. Let me see what I can do. And they'll come back and say, hey, here's where I got her. Where can you get your guy? And a lot of times that's going to be cheaper. It's going to be quicker. And there's going to be more favorable outcomes for both parties. So, I mean, it's only amplified when you're representing yourself that you have to be professional. You have to be courteous, because you're not going to be able to have those conversations if not.
Yeah, no, definitely. And it goes for opposing counsel. And, I tell clients that goes for anybody in your life right now, because anybody is a potential witness, and, you can't go to school and demand school records, can't go to the doctor and be ugly to them. You've got to be polite, courteous to everybody in your life, you know.
We just won a case because dad was polite and courteous to the dentist and always took the new court order to the dentist office, was friendly to the front desk staff. And so he would get the text messages of when appointments were. He was on all the records. Well, then the front office, one of the ladies in the front office was willing to wrote a declaration saying, like, no, when dad showed up, mom was the one who lost her cool. Mom went crazy. And mom's whole spiel for a domestic violence restraining order was dad showed up to attack her. But then we had the front office staff at the dentist office saying, like, no, dad's the nicest guy in the world. He always keeps us informed. He's always attentive to the child's needs. And mom ended up getting hit for $5,000 in attorney's fees. So it's like being nice to people like that costs you nothing, and it's only going to be net positive.
Yeah, man, that's a great example because, say in that situation, if dad was on somewhat of a bad relationship with them, called and demanded records or something, even if, mom did come in and was harassing dad, maybe they wouldn't write something in favor of dad,
They
But
called our office. They called our office and offered. That's how nice he was to them. And that's what it got him full custody.
Yeah, and if they had a problem with dad, they might not lie for mom, but they're not gonna help dad out, and give them this, affidavit. And so, yeah, man, I mean, that's a great example of how all those little, just being nice to everybody, helps your case tremendously, in ways you don't even know.
Yeah, being nice to the courtroom assistant, the judge thinking positive, like those things matter. But I mean, those people around you can make such a huge deal because I'll tell you as an attorney, and I'm sure you have the same experience, a lot of times these neutral third parties want nothing to do with a court case unless they feel compelled by how they've been treated by one party or the other.
Yep, absolutely true. Yep.
All right, so we're coming up here on an hour. What I want to do is, so you are in the Houston area. What counties in Texas do you practice in?
I do Harris County, Galveston County, Brazoria County, a little bit of Montgomery and Fort Bend. Really, the area is kind of between Houston and Galveston.
Okay, so you're between Houston and Galveston, and then where is the best place for our viewers to reach you if they're in that area looking for representation?
Yeah, I'm with Goldsberry and Associates. That's my law firm. We have offices in Pearland and Texas City, and getting one going in Houston. But just Google Goldsberry and Associates. I also have a Facebook page that used to be for my solo law firm. Now it's kind of a unused blog, but it's Ben's Law Blog. You find me there and shoot me a question, directly.
Awesome. Well, Ben, thank you so much for joining us tonight, sharing your knowledge. Thank you for your years of effort in fighting for dads and non-custodial parents. As we wrap up here, do you have any one little nugget of advice you would give to all those parents that are struggling through the system right now?
Man, I would just kind of echo what we just said. And, when you're a pro se litigant and you can't compete with the other attorney in terms of, evidence and knowing the law, but, you have your one greatest asset that you don't need to go to law school for. And that's just being nice to everybody. Because if a judge likes you, he'll bend over backwards, to even bend the law to give you what you want. So, man, just be nice to everybody. And if you can't do that, some people can't do that. Just don't be mean to people. I mean, that's a huge thing right there. If you can just remind yourself not to be disrespectful to the judge. I mean, family court is all about who's the bad actor, so
Definitely,
be nice.
Definitely. Awesome. Well, thank you. So Ben Beveridge, Houston, Texas area, Goldsberry Law. Reach out to him if you're looking for representation. I am Mark Reel. We will be back again live next Thursday, 8 Eastern, 5 Pacific on State of the Family Courts. Everybody take care.